Alto Asset Company versus Valerie Dunbar.
Personal zone.
And we need to proceed with this one, Your Honor.
All right, Ms. Dunbar.
Yes, I just
Go ahead.
just got my counselor at case manager yesterday at VOA, and they called Main Street yesterday.
All right, unfortunately, ma'am, all that would have had to happen. This was only on the strict review docket. Did you pay him or vacate?
No, I did not pay. No, I didn't vacate because I'm working with them to pay Main Street. They're my case manager. I just had surgery
Ma'am,
Friday,
based
and
on
I won't
today,
be released. I won't be released until October 6th.
yes, ma'am, I'm so sorry. Once you accept the standard agreement, though, it is your duty to oblige by it in full or to vacate. All I can tell you is today they are entitled to an eviction judgment with immediate possession. You can contact them after today to see if they're still willing to work anything out with you, but if not, you need to be vacating as soon as possible. There's nothing else that I can do at this time.
The only reason why we did this was so that I could have time to have my surgery, which was Friday, and I just got home. So that's the only reason why we had this 7-day thing, is so I could have time to have my surgery and to talk to my case manager. That was the only reason for this.
Yeah. Everything would have needed to be squared away by today at 11 a.m. And my understanding is not. Again, I encourage you to try to work with the property manager, but they do not have to. They get their eviction judgment today with immediate possession. I would advise you to try to contact them. You can also, again, looks like you already have some assistance that potentially is coming. They may be able to help you and assist you with what you're moving to next, because the eviction judgment is granted today. All right. So judgment is granted. It is with immediate possession. They have the authority to request an eviction warrant and contact the sheriff's office for a set out. It's imperative that you try to work something out with them or to start moving in and looking for your new place. But that is all for today, Ms. Dunbar.
So, Ms. Leach, nobody's talked to you? You're just going for this? Without speaking, I'm just saying, Judge.
No, I've already explained to you.
Well, I don't know what else to say.
The property manager has a duty to contact their attorney. They have not done so, and they have not extended any standard agreement offer beyond the one that was for today's review date. Again, Ms. Dunbar, you can call the property manager. Listen, that's all you can call the property manager. If they're willing to still work something out with you, then they will tell you, and then they will contact their attorney to set aside the eviction judgment and let her know how they're proceeding. Otherwise, the eviction judgment stands and you need to be moving out and perhaps using your assistance at a new location. Good luck, ma'am. Okay.
You're not telling me how many days that I need to do this, because as I said,
immediate possession. They can get an eviction warrant as early as today. Contact the sheriff's office once they get it, and within whatever their time schedule is, the sheriff's office can come and remove your belongings. Okay? But does that take time? It does. How many days? I can't give you a day certain. You just need to understand that that is the point of where we're at. I don't have a date certain for you to give. Okay? But you can also work out with the property manager when they may be contacting the sheriff's office to do that set aside. They may be willing to give you some time. Okay? So good luck, Ms. Dunbar. All right.
Okay. Go.
Will you hand me my screen box? Now go.
And it's Heron Property Management versus Laura Hall. Let's see.
Crossings at Mill Creek. Did you guys get possession or payment from this tenant?
I think this was a review of rental assistance.
It was a review date, but they had their note on me said to go to submit it, so I think they didn't get any assistance either.
We did not.
Have you all received any information from any assistance agencies?
No, we have not.
And any communication from the tenant about when they may be paying?
No.
Okay, so I know that we passed it to the rental review date, must have been based on, but I did not mark Ms. Hall present, so I'm gonna try to give her a phone, I'm gonna call the number. And we'll see if we get in touch with her, and then we'll have to go from there, so let's
Yes,
see.
ma'am.
Hello, I'm looking for Miss Laura Hall.
This is her.
All right, ma'am, this is Judge Shanisha Hickerson. I'm calling. We are on record here in evictions court in Jefferson County. So I'm calling relating to the property at 14 Place Apartment. The allegation is a failure to pay rent. We did.
No, I ain't failure to pay no rent.
Excuse me,
Okay.
ma'am, we are in
Go
court.
ahead.
We are in court. So I still ask that
And I'm
you,
at work.
well, I ask that you show some respect and decorum in addressing the court, okay? So again, we passed this, their attorney did last time because there was discussions that you were going to try to get rental assistance, okay? And
Yes.
my understanding is that did not come through. So now this is the part where we continue with the eviction hearing. Okay? So I can ask briefly, are you still trying to pay everything and stay here? Or are you trying to move out?
I paid.
When,
They gotten checks from my social worker. I just talked to her on my last visit because I have all the emails. They still holding on to the check from June, July, and August.
okay,
And I've paid with them checks.
okay. And let me swear you in. If you'll raise your right hand, let me know when you've done so, okay?
Land Pro.
All right, do you swear or affirm the testimony you provide today to be the truth, the whole truth, and nothing but the truth, so help you?
Yes, ma'am.
All right, thank you, Ms. Hall.
Mhm.
Let me ask, when did you take these payments to the office?
The office of my social worker sends them a check, and they supposed to email her back agreeing to wait for the check. And I have every email stating that they have
Okay.
agreed to accept and wait for the check. And then I
When
also
was
have
the
the
la-
last one where no one responded
When
because
was,
there's nobody in the office.
when was the last time the social worker sent a check on your behalf that you have knowledge of?
June, July, and August.
But when was the check sent? Like, when was the last
I don't know
check?
that part. They said that it's a 5-week process, or however it goes, just like when they got the $1,000 that they paid, they had to wait a while for that.
No, I
That
just
was
need to know a
added to my
date.
last one.
I just need to know a date, Ms. Hall.
But I don't know.
Ooh, we won't do that.
Let me look and see.
Mr. Ben.
It's so hard.
Meredith, are you all holding any checks on this tenant?
Meredith is no longer with us. There were some checks that were not processed.
2025 for
Yes,
$400.
August the 26th, you said for $400?
Yes, ma'am.
And do you have,
Sorry, Your Honor, this resident has a $9,000 balance.
I understand, but I still need to know the last time you all received payment.
Correct. So no payment has been posted on
One moment, Ms.
this.
Hall. One moment, Ms. Hall. Let
Yes,
me try
ma'am.
to hear from
Yes,
the,
ma'am.
go ahead. I'm sorry.
So who's on with me today so I know who I'm talking to?
This is Marissa Hamby.
All right, Marissa.
May I swear her in real quick, Mr. Benz?
Yes,
I'm so
ma'am.
sorry. Thank you so much. Ma'am, if you'll raise your right hand and let me know when you've done so.
Yes, I do.
Okay, thank you. Now, Mr. Benz will ask you some questions.
All right, Marissa, so you all received some checks but not posted them. Is that correct?
Yes, and so the manager over the property is no longer with us. When I
Oh,
came
ma'am.
onto property yesterday, I did see that there were some checks that were not posted. It totals up to an amount of $3,000. They have not been posted as this residence balance is triple that.
And when were those checks, or I guess when was the most recent of those checks received?
I believe that was August.
All right. At this point, Your Honor, I think they've held the checks and so the tenant didn't have control over it. So I think properly, they have to dismiss, but they can send a new 7-day notice for the remaining balance out the day and then file again in a week for the other $6,000+ that Ms. Hall owes.
Okay.
6,000.
Yes. So this is, I want you to understand this, Ms. Hall. Because the payments that were sent on your behalf were not returned in a timely fashion, it is considered ripe for dismissal of this case at this time. But understand then that they can refile this case if they still don't have payment in full worked out with you. They can file it as soon as, today, and it can start, they can give you the notice to, a notice, proper notice to pay the remainder or start a new eviction process. Do you understand what I'm saying, Ms. Hall?
Yes, ma'am. I'm just
Okay.
trying to figure out how it got up to that much.
I don't know,
When
and I
I
can't.
was paying rent as well. So
So
they was
you
getting
wanna-
money over from me to pay my rent.
Yes, ma'am.
Along with them
Yes,
checks
ma'am.
from them. And it says our
So-
checks can take 3 to 5 weeks to be received.
Yes, ma'am.
Do you have this agreement? I have 30 days to have.
Ma'am, let me tell you what I would tell you to do. They have new management. Everybody needs to be on the same page. Take all your documentation. Go and try to have a meeting, sit down and talk with them. And maybe you guys can come to a meeting of the minds of what is owed and due and avoid this process in the future, okay?
Yes,
All
ma'am.
right, good luck to you, Ms. Hall. But for today, the case is dismissed.
Thank you.
You're welcome. Thank you. All right, Heron Property Management versus Eureka Burial.
Present.
That one is on for a standard agreement. Jasmine, did you all get payment or possession?
We're going with possession. We did not receive payment.
Okay, because, Miss Burial is here. So you understand, Miss Burial, you had to pay or vacate by today at 11 a.m.
Well, I didn't know the time or date to vacate.
That
What
was
I was
ma-
told was this was to say whether I was gonna stay
No,
or pay.
ma'am. This is the judge before, which is not what we do. It's a standard agreement, and that's what's written on your calendar, ordered by Judge Langford, standard agreement, going to September 25th at 11
Yes,
a.m.
and she said
Mr.
agree
Benz,
with
do
the,
you have anything different, or is your client willing to extend the standard agreement to vacate only?
My
Yeah,
notes
in
are
my
for a
spirit.
standard agreement. Jasmine, are you all willing to offer any more time for her to vacate?
From what I am told, they were wanting possession today per my notes.
Thank
Right, so
you.
it sounds like we have nothing more to offer, Your Honor.
No, unfortunately,
Well, that's
whatever,
not
Miss,
what
no,
they
no,
been
Miss
saying.
Miss Burrell,
Communication
Miss
is
Burrell,
terrible.
Miss Burrell. It's not about
It's Burrell.
communication. What is it?
Burrell.
Burrell, and I apologize. for
It's
saying
okay.
that.
Everybody
So,
messes it up.
But what is written from the judge previously is a standard agreement offer going to today.
I know,
this-
I understand that,
but
but what
that
she
means
told me
to
on
pay-
the phone,
Now, so again, but the judge is what tells you is to pay or vacate.
I know, she also told me
So if
on
they
the
don't,
phone
if you don't
too.
write anything else out, they don't have to extend any additional agreements. What is feet to the fire is what the judge said last.
But I even talked to Jasmine them and asked them, when do I need to be out? Everybody acting like they don't know. They said it was up
But
to
then go
you.
back to the judge, what the judge said last week, which is, the week before, because this was
Right, and
before the court, September
she didn't
16th.
have a time
Yes, we did. It was September 25th at 11 a.m. That's why you know to be here.
to say to stay or vacate.
No, to pay or vacate by today at 11 a.m. That's the standard agreement offer. We do these every day.
I'm not
So-
saying you didn't, but that's not what was told to me. That's what I'm saying.
But-
And then I've been trying to tell them so I could vacate,
Then you just
But nobody
vacate
told
before
me the
today at
time.
11 a.m.
or I didn't vacate before 11 a.m. I had to
I'm
work.
so sorry, ma'am. So
And
they
that's
are
not what was
entitled,
said.
they are entitled to an eviction judgment today. It's going to be with immediate possession. With that, you need to start moving out as soon as possible because they have the authority to get an eviction warrant as early as today. Then take that warrant and contact the sheriff's office for a set out. You may be able to reach an agreement with them that they won't do the set out, knowing that you're going to vacate on your own.
That's what I was trying to
But
do.
that does not, no. That does not mean they don't get their judgment today.
Yeah, I'm not saying that. I was just trying to get a time so I can be out.
I don't know, and I can't give you that time because one, I don't know it.
Okay.
Right? What you can do then is to work with them and say, okay, you have your eviction judgment. I'm gonna start moving out, they may delay contacting the sheriff's office.
Okay.
Okay, but then if you guys have been working things out, you've been able to talk, really what you want to do is continue to have good negotiations and good discussions, because you can say, are you willing to set aside the eviction judgment by contacting your attorney, Mr. Benz, and asking him to file the paperwork? Because I was not able to move out, and I get it, but I'm working diligently to move out. Here's your keys. Can we do the set aside now? They usually won't do the set aside till they have their possession.
Okay.
So have that conversation. And then hopefully it might have been what you're trying to relate to the court, but it may be just some misunderstanding. But that is what I'm telling you today. You understand that, ma'am?
Mm-hmm.
Okay. So eviction judgment's granted, it's immediate possession. Talk to them and work with them. They might be willing to tell you when they're going to seek the eviction warrant and contact the sheriff's office. So that may give you time. But then at the end of them too.
Yeah, that's why I was
Set
asking
aside-
Jasmine this
set-
morning.
Set aside.
Okay.
If they're willing to, which they not most of the time they are. And
Okay.
Mr. Benz, their attorney, files them all the time.
Okay.
Okay?
Thank you.
All right, thank you. Thank you, everyone. So again,
Do I just call them to rent out?
you call the rental office and talk to them, because they know they get the eviction judgment today, but they can say, okay, Ms. Burrell, I'm so sorry. We're not gonna start the process. Go ahead and keep moving out, turn the keys. And when you turn in the keys, remember, say, are you willing to do any type of set aside so I don't have this eviction judgment on my record, okay?
Okay,
All right, thank you, bye. This is Danica Alford versus Charles Yates. All parties come forward.
Morning, Your Honor, and David Yates, in fact, it's based on a C. David Yates LLC, a company that owns.
Okay. And you are Miss Danica?
Alfred, yes.
Okay.
Judge, if I may, just a quick,
Yeah, sure.
if it helps, this is a case that's based onto a rental agreement from a past tenant that filed a lawsuit in small claims based on a rent deposit that was claimed. We filed a counterclaim and answer that was served on court at our last court date. It was filed, but also served by the sheriff in open court. No answer was filed on that, and then we received it was postmarked the 5th, but on Tuesday, a motion that said extension of time. It should be in the court's document saying additional time to file an answer, but no basis or information for excusable neglect or what that is based on. The reason that I have not filed and not do a motion for default, but mostly I wanted to on court an open record. There's a couple of things that work with this case. One is it was Section 8, and when she didn't move out before the end of the Section 8 period, besides of all the damage that I've submitted to the court, which was up to a couple of $1,000s. But there was also a threat that came through via text message, and that's why I felt like it was necessary to file the counterclaim and get it in court that lays out because I'm a state senator and that the claim that I'm committing a crime and that she wants her deposit back, or she's going to make sure she tells Section 8 that she wasn't there in the month of February, even though it's counter to the claim that she was on there. After that, Section 8 filed a motion to receive their rent will come back in that amount. And so me and instead of just filing default, I wanted to make sure because I worry about this kind of allegations and threats. So I want to get that in open court as well.
Duly noted. And Ms. Alford, I swear you need to raise your right hand. Do you swear or affirm? That's it. You're asking for an extension because you didn't know you had 20 days to file an answer to a counterclaim.
Yes, sir. All I know is we was going to court on the 14th of August, and then they gave me another paper. And I didn't know, I just happened to go to I called the paper, the little yellow sheet for the lawyer to get some type of counter because I don't know nothing about any of this. So they referred me over to the law library, and they was telling me that I had 20 days. I never knew. So then when I came back to the small claims, they was telling me that it was out of small claims. So I just don't know what's going on.
But you filed a complaint.
Yes, ma'am.
At the end of the day, is your duty to understand what is going on once you start court proceedings.
Yes, ma'am.
Once you initiate court proceedings, it is upon you yourself to have to take the due diligence to understand what all that entails once you sue somebody. All
Okay.
right, so not to say this is a term of art, so I don't want you to take this the wrong way. Ignorance of the law is no defense,
Mm-hmm.
nor is ignorance of what you're supposed to do once you start a court proceeding. Okay, and so it's you're gonna have to understand your duties and obligations once you decide to come to the court for a remedy.
Right. Well,
So you came to the
I'm sorry.
court, and I did. This is a quite a lengthy case for me to try to get to the bottom of it, to even try to figure out. I know it started as small claims. Once there's a counterclaim, it removes it from small claims. That's what-
That's what I didn't know.
But that's what you got notice about.
But I had a court date, but they said it got removed.
Because they found a counterclaim.
So I guess that's the ignorance of the lack of law. Okay.
And I do, Judge Langford is, I think she's standing by to it, but we did have an explanation in court, and then it was served by the sheriff.
Yes, I am primarily listening. Thank you, Mr. Yates, for pointing that out, but I absolutely recall this, and I absolutely recall that I did inform all the parties of the counterclaim and that would be moved. So I just want to say that I do absolutely recall this. Thank you.
Right, I tabbed it yellow, which that's all I know, served in court, counterclaim served in court. But again, that starts the running of the clock.
Can I
That
say
was back on
something? I'm sorry.
August 15th. Yes, ma'am, Ms. Alford.
No, I wasn't saying that I didn't know that I got served. What I was saying was I didn't know that the other court date had got removed and I had 14 or 20 days to respond.
Right, so then you
Yes.
filed this though, right? This is a handwritten,
File what? The small claims or the,
Reply
to
to
be here
counterclaim.
today?
there's a reply to counterclaim. Did you ever get a copy of this?
He should
Yeah,
have.
yes, John.
Okay, I thought you
Well,
did.
that's what I said. It came on Tuesday. I brought the envelope that it got
That's
mailed
what I
on the
had got
5th.
from
Okay.
the law
Yeah.
library.
Okay.
That's when
So then
I
you
went
handwritten-
to
so,
the
okay.
council,
So-
and that's when she was telling me, like, giving me the outline, but she was just like, basically,
Okay, so let me just say,
Okay,
so
go.
then, so because this is what it seems like, and then like, it's kind of like, I don't know, let me see, let me go back to, did the answer come after? I'm still trying to
That's
follow
what I'm trying to
this.
figure out. What is the answer? Is it more evidence? So this is still ignorance of the law. Okay.
Sorry. Okay, yeah. And again, when it's sent to you in bold writing,
What's
it
sent
usually
to me?
says the counterclaim. And
They
it's,
just gave me a paper,
was it given to you in open court?
You judge,
Yeah.
it
The
was
civil
both-
summons?
It was filed,
It was-
it was mailed, and it was served by the sheriff in open court,
I didn't get
with the
anything
direction of the
in there.
judge. And they actually printed it for us there and.
Okay, wonderful. And so when you got that paperwork, do you have it with you?
No, ma'am, it's at home.
Alright,
I got it in my
it
phone. I'm
says-
sorry.
You're notified of legal action as filed against you in this court demanding relief is shown. The document delivered to you with this summons, unless a written defense is made by you or by an attorney on your behalf within 20 days. It's in bold. It would,
And was that on the written or
Mhm.
was that?
it would have been one, it would have been handled that.
I
something
didn't
like
get that paper. They didn't hand me that paper.
Did they
just
hand it
handed-
to her?
No, they just handed me
The summons?
the
Okay, let's move past this.
the
I don't know.
plaintiff or something like that. And it was just saying what he was, his
What was
counterclaim.
handed to her, the actual counterclaim, the pleading?
Judge, yeah, the basis of it, failure to state the claim, but my concern on this more than anything was the threats of.
Of course.
Of fraud and criminal activity in the state senate. And so I felt the necessity, obviously we cost more than the deposit, and I coming back to court and these things. And we did the counterclaim because we did have substantial damages.
Do you have that with you? I would like, if you don't mind, because I have some concerns.
Yes, sure.
A threat. Oh, and that's what I wanted to ask too about. That's what it was, because in my knowledge, in my stuff, he did get paid for February. I
Let me
wasn't
see
there for
how this
February.
reads.
Yes, ma'am.
We're gonna see how this reads. All right. I'm gonna read it for the record. Oh, it was brought to my attention that you all were paid for a month of rent for February, if you being the state senate committee, a crime I just want, you being the state senate, I think senator, committed a crime. I just want my deposit. I can turn you all in because I wasn't there and was paid. I'm trying with you all because I like y'all, but this holding on my deposit is crazy. I'm proceeding forward over 800. Is that the text message you sent?
Yes, ma'am.
On what basis would you send that?
Because I
What's the
did.
crime?
What?
What's the
Well,
allegation
because he
of a
said
crime?
that I was living in there on February. I was gone. He received his, I moved out the 31st of January. He was still receiving rent. That's why I said I was informed from Section 8, I still have the paper, that he received the rent for the month of February, which on his counterclaim, it also says that he didn't receive, he basically lost the money for February, but he got paid on February, and that's what,
Go ahead, Mr. Yes,
that's
I'm
what
listening.
a
I can
piece
listen and
of,
read
okay,
sometime.
that's
I
what
want
a
you to
piece
keep going.
of that's what one of the evidence in my, I don't know if you got the file. Yes, ma'am. It's in there. But I can show you the.
All right, but you yourself said I moved February 2025.
No, I didn't. I moved 31st of January.
You put that in your complaint? This is your complaint, your handwriting, correct?
And it said I moved.
That's
No,
what you said. You said that. You wrote this.
I wrote, I'm sorry, can you read that, please?
I lived in the house for 5 years, and this just says, I want to let you know, I moved February 2025. House was clean for the most part.
Before, I'm sorry.
For the, huh?
It was supposed to say before, I'm sorry.
But it didn't. How did you? And let's even say, how did you move out from the unit? How did you acknowledge that you moved out?
I moved out. I had packed up all my stuff. I have a video saying that an empty house. I was gone.
One moment, Miss Alford. When did you receive knowledge that she had moved out?
Judge, we have text messages back and forth several days. We went over there, the house had stuff in it. We got cited by IPL because the couch was out front. I have a copy of this
I
into
also
it.
have video.
Hold on, no,
I'm
one
sorry.
moment.
I'm sorry.
I'll
Yes, sir.
give you the
Into
opportunity.
it. And so my wife was just trying to handle the matter. On February the 2nd, we were back over there and it was a mess. You could see the house is empty, but stuff everywhere, couches.
When did you receive
The
keys?
back on the February 3rd.
It was the 3rd, and I had resent them a video on the 5th of the house was
The
empty.
5th of what?
February. The couches was in front of the home, which I also hired Holt and Reed, general contractors to come remove
So
that.
let me just stop through that.
Okay.
You're not moved out until you're moved out. You're not moved out until you're moved out. And being that this is normally, this also said eviction court, it is acknowledging that you have moved out, you've taken all your belongings, relinquished possession, and handed the keys. If you're still having discussions after February 1st, after January 3rd, you have not fully vacated.
Well, I just
So-
moved the couch. That's all. I removed the couches
So-
from outside of the yard.
And that's probably why your small claim statement is more accurate by saying I moved February 2025. That's actually an accurate statement. So the accusation against anyone, and including elected official, because it's a higher threat. As you're saying, it is a higher threat.
But what is the threat? That's what
That you're saying as a state senator, you should know that you committed a crime and I can
Right.
turn you in. What is the crime?
Okay,
What is the crime?
the paperwork said, and like I spoke with Section 8, on that paper, if you look through the file, it said that Mr. Yates was paid.
You did not move out till February.
I was gone 31st.
Your own statement, your own testimony. I'm not going to argue back.
No, no.
No, whatever me.
No, I didn't. I said, no, ma'am.
Probably don't know me. Okay, listen. Your own statement is contradictory to what you're saying. I've already tried to explain to you what a full vacate means. You were not fully vacated by your own testimony today until February. You were not. But there is a way in which you fully vacate. Your own testimony today tells me you did not. You still had items on the property. You still had the keys. By nature, you did, because you just told me you didn't return them to February 3rd. I'm listening to what you're telling me. I'm retaining it. I'm used to hearing some of these arguments. That's why I'm trying to relate to you. Okay, so then when you say in using the title in today's climate, I am letting you know it's an added accusation. He can say he can call it a threat. You can call it an accusation. You can say, I just wanted to make sure because he understood his title and the way the text was that I can turn y'all in. It's accusatory.
But he also slandered me as well. But okay. It just seemed like he gets special treatment because he is the state senator because.
So now you're accusing me
No,
of
I
giving
did
him
not.
special treatment?
No, I did not.
Who's giving him special treatment?
Even the public defenders that I have spoke with, they would not take the case because he is.
Why would a public defender take your case?
Well, I'm sorry, the lawyers that I was pursuing, I apologize. They were saying that they didn't want to go against him because he is the state senate. So it's like I'm in a.
And I'm not here to kind of go into like what, because that would be speculative of me to say. There could be various reasons why an attorneys may not take your case. knowing, again, I know him as an attorney.
That's fine.
So I'll tell you this. People, he has cases. He has cases that people have taken against him.
I
He has to defend
I never
cases.
said nothing wrong with this man.
Well, I'm just saying, so there-
David was okay. I respect Mr. Yates. You know, it's just to this point because, like I said, I was going to keep up his home, and then when
Well,
it
you were
came
there for a long
to,
time.
I'm sorry.
You were there for a long time.
Yes, ma'am. I was going to keep up his home, and then when it was time for me to move, it was all of this, and I even asked Mr. Yates for a walkthrough before I
didn't see
left,
that.
and he denied.
Well,
He denied. He told me that he was going to have contractors to come in, his people to come in and walk through.
Well, I see those text messages. I think it was denied and misunderstanding, but let me give him, since you have stated that, and I want to make sure he has an opportunity to respond to how the walkthrough went
He also
through.
said he did not receive the keys, and Lindsay got the keys, and that's also in text message.
February.
Yeah, and it was said that you had found your phone, that it got packed up into a
No,
box.
yeah,
And
it-
and that's
my
why
stuff
there was
was
mine.
packed
And then,
up.
so we went by there. I believe it was on the 5th, they came in, and it was a mess. And they had told me, or asked what it would cost to clean. It's very expensive. They would have to skim all the walls, but there was a really bad odor. And then there was a floor that had sunk in from water and mildew and everything. They said it had to be taken up. We had asked before in the text messages about the walkthrough for you, and my wife repeatedly asked, it looks like, are you going to be out before the 31st? Are you going to be out? Judge, we had, it was signed on the 20th, that she was going to be out. And we have a back and forth paper where she's saying, I need you to get this signed, because I want to leave. And my wife did not want to plug in that number herself, the date you're going to move out. So we got those text messages back and forth too. But then, when we did get it in, it was a wreck. It was in the month of February. They didn't have it. The stove by itself was $360. They said to clean. The blinds were destroyed. The roofing was destroyed. So they came up with $1,900 that day immediately. And they told me that I may be having mildew issues into it. So they mitigated the damages.
Thank you. Okay, response?
Yes, please.
Yes,
Ms.
ma'am.
Hickerson, or Judge
Yes, ma'am.
Hickerson, excuse me. If we can start back, I spoke with Ms. Yates back in December of 2024 about this move date paper. I had my paper. When I signed the paper, we were supposed to actually meet. Normally we would meet at a BP like on Taylor Boulevard or something like that. Me and Ms. Yates will meet.
Yes, ma'am.
I signed the paper at 1/5 because of January.
Okay.
That's
The
when
paper is the
cancellation.
cancellation.
Yes, ma'am.
That's
the
why I
cancellation.
figured that's what you're talking about. I just want to make sure.
Yes, ma'am, the
follow.
cancellation lease.
Yes, ma'am.
And me and Lindsay was going back and forth, and I guess she was saying that she was busy and she wanted to make sure that David was on board and I think he was out of town or something.
Okay.
So she wound up emailing it to me, and it was on 1/20.
Yes, ma'am.
And that's when I was like, hey, Lindsay, what's going on? Because like I said, I signed it the 5th of
Sure. So there was some
January.
delay.
You know, ma'am.
That's
Yes,
fine.
ma'am. So I'm like, what's going on? What's going on? So
There's the
I finally got that back. I'm sorry.
Can I just kind of cut across the field at this
Yes,
point?
ma'am.
You're suing because you want your deposit back.
Yes, ma'am.
That's where let's just cut across the field. You're suing because you want your deposit back. They're counterclaiming because not only do they feel like you should not get your counterclaim back, but it exceeded even what your not your counterclaim, your deposit.
Can I
You
also
understand
say I have
that's
video?
the argument?
Yes,
though?
ma'am. Can I also tell you that I have a video when I left? I also have video and audio of with his his father-in-law.
Sure.
Saying that the house had already needed work. Because if you look in my
I'm fine.
if you look at my answer, I have my failed inspection from Section 8, which David have never did any maintenance on the house for the 5 years I have been there. Never came and visited the home like I have asked plenty of times. Hey, David, the blinds. Hey, David, the floor was sinking in because the toilet had a crack in it. He had to replace the toilet, and that's what it was. The tub that he had in the bathroom was too heavy for the floor. So when Section 8 came and did and failed the house, he was supposed.
So that's the crux of this case. That's the crux of this case. And at this time, I understand the argument.
Did you want to see the videos or listen to the audio or anything?
No, ma'am. Because I'm going to pass it for here. I'm going to pass it. I mean, we're not going to, this is again, I think this was put on my motion hour again.
Yes, ma'am.
Because you have filed an answer, albeit
Because I don't believe an answer's been filed
Is that
at
not,
all.
oh, I thought this
What
was
is
an answer.
So I guess I
There
gotta
was-
look, Google it.
I thought it was an
don't know.
answer.
Yeah, no, actually, it's just, all it is, apologies.
It's titled reply to counterclaim, but you wanted to say answer to counterclaim?
What's that?
I thought-
Yeah, it is, well, because I had a 12B6 failure to state a claim, into it because there was no
There's
claim of
nothing.
action, yeah.
Okay,
Yeah.
so, and again, this was on September 2nd. Again, I apologize for trying to follow this. Because the counterclaim was August 14th. This was filed on September 2nd. Did I miss something in between there? No,
I'm
that
not-
Mr. Yates.
Judge, I mean, just for a resolution here, I had no intention of filing a counterclaim against the tenant after this. I know it's a lot of damage. I chalk that up as a business expense. I don't like to go after people, and that's why I'm not great at, I only have one other residential property.
Yes, sir.
But in this situation, once there was a threat there that got put on record to Section 8, I felt the necessity to bring it to the court. If Mrs. Alpha would like to sit down and maybe dismiss all the matters, I could dismiss my $2,500.
I
She
have
deserves.
sleeves for 3 years living in your house and you knew that.
First of all,
So that's fine.
ma'am, there are so many different things that the court would have to go into.
That's fine, but I have
Because,
receipts.
no,
I have
the
receipts that I had
Ma'am,
fleas for 3
listen.
years that I lived in David Home. And when I gave him the deposit, that house should have been ready to live in, not with animals that I don't even have.
5 years ago? Okay, so I'm
Yeah,
gonna
5
talk,
years
we're
ago.
gonna fast forward 5 years because you stayed there. And the only thing the court would.
In 5 years, I had alley rats and the cats that went in my
Would you
house.
like me to
So
finish? Would you like me to finish? When we get to 5 years later, the court's gonna look at what the condition of the house is when you leave.
Mhm.
The court would hear evidence. What I find that the person living there for 5 years may be responsible for versus what a landlord would be responsible for. Again, things that got fixed at some point in time in those 5 years, moving them closer and relevant to the time of move out are the things that the court looks at. The court looks at whether it's beyond normal wear and tear, which again, most tenancies end with certain damage assessments that are going to be attributed. It's going to be the responsible of the tenant, the responsibility of the tenant versus what would be the responsibility of the landlord in the normal course and scope of them having to have, rental property. It's sometimes a little gray, but how much is your deposit?
my deposit was 800.
All right,
That
so
was living over there. And you wanted more money soon as I got over there because it's.
no, you're going 5 years ago. We're not going back that far. We're
But what
not
I'm saying-
going back that far.
Okay, Miss-
So you believe you owe that it was an $800 deposit you
Yes,
should get
ma'am.
back. If
I
I
upgraded his
find
home.
proof, what?
I upgraded his home.
No, okay, so if I find proof, whatever you did while you lived there and the benefit of you, that's probably gonna be a little bit,
I have
so
the document.
this is about damage.
Right.
Alleged-
The only damage was the blinds. And in my sunroom, because it was made up like a daycare, the little sticky things, the walls was like
You're
thin.
like
So
Mr. Yates
the
trying to
paper just
resolve
came
this.
off.
I'm gonna pass it for a hearing. At the hearing, if you can, and again, this is a matter of, I don't know how,
Okay.
again, we're gonna talk about what you've already talked about. There's a removal of couches that costs money.
And I paid it, $250. I have the video. I also
Okay.
have the receipt in there.
Okay, there's going to be everything that the court will consider as the tenant's responsibility for any alleged damages or work that had to be done, as opposed to any damages that any damage that would still be the responsibility of the landlord as a property manager. Okay, you need to understand that
I'm understanding, or is the ignorance of law. I'm listening to you.
I don't understand. What do you
I
mean
don't
the ignorance of
either.
law?
I'm just waiting. You just said that you was gonna send it to I'm waiting on the court date. That's it. Cause like you said, it's an argument between the landlord and the tenant. So,
And at this time, I would just renew my oral motion for default, just after hearing orally in there.
As far as the oral argument for default, I'm gonna deny that motion. I do find that as a lay person, again, it sounds, I feel like you feel like you're being attacked, but it's just a terminology. As a person without an attorney, the court finds that what was submitted on, I think it's September 2nd, sorry, that was deemed reply to counterclaim will be sufficient for a responsive answer to the counterclaim. Again, and then one of the things is that, she states it denies allegations for failure. And so just note on the record, Mr. Yates, oral motion for default judgment is denied. Do you understand what I mean when I say that, ma'am? All right, so he wanted me to grant a motion, default judgment, which would be that you failed to answer a response, and then that would he would then be entitled to judgment. I'm denying that today because I find that you filed a response on September 2nd. That was that written response you did, and that the case can now continue on. Continuing on is discovery. You guys will exchange documents. You'll have more discussions, and you may be able to reach a resolution and come to and come to a resolution. File that with the court, or again, going to continue to do your due diligence about what happens if you cannot resolve it, which could very well also end in with a jury trial or trial, But it could also be that he could submit a motion that the court would look at and find that that there's there's no factual basis in dispute, or that could make a ruling, a written ruling. Okay.
Yes, ma'am.
All right. So that's you. So you want to just keep this on a court docket for review?
Yeah, just promotion practice if we can.
Okay. So we're just going to pass it, but I'm just passing it for review. It could be review of where the parties are at, settlement negotiations. If there's any motion that comes before that, you'll get notice of it because he'll notice you. You'll say, "Hey, I put this motion out prior to this date." Let's go out. My past admin is October 24th.
So what was I supposed to get in the mail?
Excuse me.
What was I supposed to get in the mail? You said something about I was supposed to get something in the mail.
You talking about the summons that you got open? That you got in open court?
No, I came down here to.
Right, but I'm saying I might have said that you.
No, Mr. Yates said I got something in the mail. I didn't know. I haven't gotten anything in the mail, so that's why I was asking. What was I supposed to get in the mail? Okay.
I might have misspoken, but it might have just been how were you originally served a counterclaim. I'm not sure.
Yes, ma'am.
But at this point, I can tell you're not missing anything that should have been mailed to you. Okay, we're just going to go forward with the case.
Okay.
Your case, your claim, sir, is surviving. His counterclaim is surviving at this time. So you want to just see if there's any negotiated settlement that you can reach. If not, make sure you understand all your options going forth now that the case continues on.
Yes, ma'am.
All right. Anything else, Michelle?
Judge, the only thing is I'm scheduled on that date in Lincoln County. It's another past due.
How about November 7th? And this is just review, because a lot of these cases I don't even give a review date for, but because I want you to understand and just feel you have an opportunity to come to court, be heard. November 7th?
Yes, Your Honor, that works.
Miss Alfred Kent, does November 7th at 11:30 work for your schedule? The court does not send a notice about this. You just got to put it in your calendar. My deputy will hand you a yellow card just so you keep up with, okay? And so again, I'm noting continue for review, 11/7 at 11:30. And that's all for today. Thank you so much.
Thank you, Your Honor.
Oh my God.
You have got to be kidding me. What is going on today? This is joke. Today is an absolute joke. He's an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No, trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.